Welcome to the Customary Land podcast. I'm your host, Spike Boydell. Today I'm joined by my friend and colleague, Professor John Sheehan. John and I have known each other for about 30 years in the Indigenous customary land space, and we've collaborated on a number of projects over the years, and we're both involved with customary land solutions as well. But it's really nice to sit down with John, who's an adjunct professor at a couple of universities. Remind me which those are, John.
Bond University, Spike, in Australia, and Jan Evangelista Perkin University in Ústí nad Labem in the Czech Republic, which is associated with my work for the European Commission. So yes, one's an adjunct professorship and the other one is actually a research contract position with the Czech University.
Thank you for giving me those names, because that was a bit too hard for me to remember. I always get the Czech University a bit jumbled when I make mention of it. John and I have both been, as I say, in the Indigenous customary land space for about 30 years. John, you were very involved through the native title period, and about 4 years ago, we recorded a video together where you gave your sort of feelings after the Timber Creek case was determined here in Australia. And obviously we're talking to a broader audience, but there are some useful lessons come from that Timber Creek case and how they thought about various aspects, which is, I think, going to be the focus of what we're talking about today.
Thanks, Spike. I'll give a very brief mention of it. As you said before, we had a conversation as a result of the decision of the High Court in Timber Creek, or Griffiths case as they call it, and it was the culmination of a whole series of cases, starting out originally with Justice Mansfield as the single judge in the federal court, the trial judge, went to the full federal court, and then ultimately, with the consent of both of the parties, it went up to the High Court. It was, in some respects, it was a long-awaited case in respect of compensation for native title, because it had always been euphemistically described as being the elephant in the room, because native title is not capable of being sold. It certainly is capable of moving around within the relevant language group, and of course it is capable of being extinguished by the Commonwealth Government. Now, as a result of that position that native title's in, it isn't like the valuation of other non-Indigenous property rights, which we can clearly go as trained valuers. We can see a marketplace, and then going through the relevant legislation, we can deal with compensation. Native title was always going to be difficult because, one, you don't have that access to normative market considerations, but of course at the same time it's driven by the protection which comes out of initially the 1992 Mabo case, and then on top of that, of course, the partial codification of native title in the Native Title Act 1993 by the Keating government. I mention that legislation advisedly because it established the framework under which compensation is generated when there is a compulsory acquisition of Indigenous property rights, known as native title. Now, native title is protected from arbitrary compulsory acquisition. It can't be taken, as can any acquisition under the Commonwealth provisions. It can't be acquired without compensation. And more particularly, as you said in your first podcast in this series, it can't also be taken without attention to the constitutional protection, section 5131 of the Constitution, which deals with the issue of just terms compensation. Now, one of the things about just terms compensation is that while it doesn't apply to the 6 states who still retain their pre-federation rights in the constitutional split-up, which led to the Australian Constitution coming into force on the 1st of January 1901, the states held back their power over land management. But one of the things that's not commonly understood is the states also held back preserved any rights they had to compulsorily acquire private property rights essentially on whatever terms they decided. And there's been a case, of course, back as early as 1915, known as the Wheat case, New South Wales versus the Commonwealth, where it was quite clear that the states retained their sovereignty to make laws for the compulsory acquisition of private property if they decided, even without payment of compensation or any compensation or even partial compensation. That's not the case of native title. Native title has to be compensated for if it is compulsory, extinguished, acquired or impaired as a result of the protection offered under Section 5131, the just terms.
Now, can I just stop you for a minute? You used the word extinguishment, and this is something that is almost an anomaly, because the whole idea of recognising customary rights, and obviously the native title legislation here in Australia at 1993 predates by 14 years the UN Declaration on the Rights of Indigenous People, but extinguishment per se isn't an option in the aspirations of the UN Declaration, because you cannot supposedly alienate the inalienable. So, I mean, this is an aside, but it's perhaps earlier than I expected to ask this question, but it's germane to it, and that is, you've got the situation where the native title legislation has enabled recognition of native title rights, but that is then something that the governments can extinguish and compensate for. That's very much at odds with the subsequent aspirations of the UN Declaration on the Rights of Indigenous People, because you can never extinguish the inalienable. I mean,
yes, look, it's an interesting argument, and I listened carefully to your first podcast. The strict position, of course, in Australia, and in fact in any modern nation state, is that all private property rights and interests, that is, interests which aren't held by the nation state, are precarious. Now, that doesn't matter whether it happens to be the land, real property on which we're talking today, or it happens to be native title. And whilst it may sound a very hard comment for me to make, the reality is that the nation states preserve to themselves the right to commute any other private property rights that may exist to themselves. Now, whether or not you're Indigenous or non-Indigenous, and whether you live in Australia, or whether you happen to live in New Zealand, Canada, or even in Europe, no private property rights holder, whether they're Indigenous or non-Indigenous, wants to have their rights taken away from them. But that's the power which lies within the nation state. As difficult as that is to accept, and I certainly understand what you're saying in relation to the UN Declaration, but the reality is that the nation states, modern nation states, preserve to themselves the right to commute private property rights and to extinguish them and to take them back. But of course, in those, I mentioned the word, those modern democratic nation states also have legislation which enables us to at least give some compensation back to the level at which we, as a nation state, would feel comfortable with the fact that we've not arbitrarily extinguished those rights without compensation. I mention that in passing because some years ago, in a case in 2001, Justice Kirby, in Durham Holdings versus New South Wales, passed a comment, and he said that an extreme departure from fundamental rights may be challenged on a constitutional basis, given the role of the Constitution, and he's speaking here about the Australian Constitution, for judicial protection of private property in the face of legislation that is substantial. That was his words. Kirby at paragraph 72 in Durham versus New South Wales in 2001. Now, I draw upon that because it actually has its roots in an earlier case in 1988, which was Union Steamship Co. versus King. And in there, the possibility was actually advanced in that 1988 case of a constitutional limit on the powers of the states to actually acquire rights which would be essentially unfair In other words, in an advanced democratic system of government and in our common law situation, there is a deep-rooted defence of private property rights. So they can't, even though the states, I know, draw back upon that 2015 case, the Wheat case, as I said, where they can do what they want. But realistically, what Justice Kirby has said is, look, I'm sorry, in a modern nation state, you really can't do that. And given the opportunity, I'm quite certain the High Court would probably look at something like that. And that leads me into the next point I want to make. And that as I said, you might recall a few moments ago, that no one wants their private property taken away, whether they're Indigenous or non-Indigenous. And I'll just focus on Australia at the moment. As uncomfortable we might be about that, there are always situations where the nation state or its agencies are going to have to do things which is in the purview of the nation state of being something that is reasonable to do, being a modern democratic country. We somewhat unwillingly accept that. And indeed, some of my colleagues in Central Europe have, as their countries, and you can see I'm thinking about, for example, the Czech Republic, as they've moved out of a command economy situation, a country which is driven by authoritarian systems of government, to a more liberal, what we regard as the European more liberal social democratic structure, they themselves have had difficulty understanding that while we're back to preserving private property rights, at the same time you're also inserting in the newly democratic countries that did have communist control a provision for them to arbitrarily, at the will of the national government, commute private property rights. And you can see there's a tension there. We in countries like Australia, New Zealand, Canada, the US, certainly England, we recognise that the modern nation state must have that power to efficiently function. We may not be happy with it, and we certainly sometimes can even have that overturned if we don't believe it's in accordance with the legislation. But deep down, it lies with the purview of the nation state to undertake that, as uncomfortable as might be with it. What Justice Kirby said in that case, Durham, was that he also felt that there was a possibility that even Section 5131, the just terms provisions in the Commonwealth Constitution, may well be so embedded in the notion of the Commonwealth of Australia as a modern nation state, that may even be possible to overturn these residual powers of really arbitrary acquisition, even without compensation, which the states, of course, can do. But I'd have to say, you'd have to be saying that would be a very dangerous thing to do in the current, in 2023. Having said that, that brings us to the issue which I wanted to talk about today, which is the issue of the way in which we have to address that particular part of native title within the Australian legal framework. That is the bit which is really dealt with in Timber Creek under the purview of compensation for cultural loss. We don't have that when we're dealing with the acquisition of non-Indigenous property rights beyond a very small additional payment, perhaps for the disturbance of the fact that it is a compulsory acquisition, much against the grain of the owner, but the owner accepts that the power of the state is such that it has to be yielded to. Now, in that case, we don't deal with those issues. We regard land as being a commodity in the Western European model, and so consequently the little bit of extra payment we give someone for the disturbance, the question of forced acquisition back to the state, the Commonwealth, we regard those things as being a final payment just for the interference of their life as a result of that. Native title, of course, is quite different, because native title doesn't have its roots in the Commonwealth, in the Crown grant. It has its roots in an ancient culture. And part of that ancient culture is, of course, the question of a cultural input into it. Now, in Timber Creek, there was the first addressing of how do you compensate for this interference with the culture of these Indigenous holders of these lands. Well, a couple of issues come to mind, first of all. One, we don't really gain any assistance from the current property compensation law and practice that exists for non-Indigenous property rights in Australia, excepting, as I said before, this little bit of extra payment for the sentimental attachment, whatever it might be, but it's very small, it's minuscule compared to the market value of the land. However, in the case of native title, it's possibly the largest component, and we've already seen that with the decision in the High Court when they looked at the compensation that was due to the people in Timber Creek, and as a result of that, the largest individual component in the compensation package was in fact for cultural loss. Having said that, how did the court approach that? And what sort of lessons, as you said in your kind introduction, what sort of lessons do we gain out of that? Well, I've often said to students over the years, and students that I've got at the moment as PhD students, you need to be careful when you're looking at High Court decisions, because the High Court in itself often takes an unexpected approach to things. A prime example was when Murrundu Yanna speared the crocodile. And of course, it was contrary to the Queensland fauna legislation. The ranger, he was fined. Ultimately, of course, Yanna versus Eaton, as the case is known, went up to the High Court. And of course, we know what happened, of course, is that there was a transgressing of the state's legislation, which it was argued that it protected fauna, and fauna was actually in the purview of the state of Queensland. It was essentially owned by the state of Queensland. And of course, the High Court unexpectedly turned its mind to, well, exactly what does the Crown really own? And so before they dealt with the issue of whether or not Murrundu Yanna had done something contrary to the state's legislation, did in fact the state itself, that is the state of Queensland, actually own such things as natural resources like fauna and flora? And they extended, of course, to other such things as we know within the common law: fire, air, water. And so all of a sudden we had a case which was about an Aboriginal man killing a crocodile contrary to state's legislation, to the court saying, well, before we deal with that, let's have a little look at whether or not the state actually has the power. Now, that I'm quite certain was something that was unexpected within the legal minds of the Queensland government at the time. But of course the High Court did just that. It had set itself a question to be answered before it dealt with the bigger question of whether or not Murrundu had actually interfered with something that was owned by the state. And of course, the High Court came down and said, no, of course the state doesn't own crocodiles. It doesn't own those sorts of things. It may have land as a result of the radical title and the rights that it holds as the former colony of Queensland, but even that at common law never extended to such things as flora and fauna, and it certainly doesn't extend to such things as water. The consequence of that, of course, was that subsequently in 2000 we ended up having New South Wales and Queensland producing the division between the traditional locked-in position of land and water together. They tore apart that locked-in position, and so we had separate rights to water. But what's intriguing about that is that in the two states' legislation, they avoided vesting water in the Crown. The reason why they did that was that in Yanna versus Eaton, the High Court had stated clearly, you, the Crown, in right of the state of Queensland, do not have private proprietorial rights in water. Then they turned their mind, of course, to the fact that did the Crown own the crocodile? Of course the Crown didn't own the crocodile. But my point in this very short example is that you need to be very careful when you go to the High Court, because the High Court often says, well, that's an interesting question, and leading up to us answering that question, we've got to clean up this underneath here, and that's exactly what they did there. Now, I mention that as a precursor to the broader picture that I'm raising here in relation to Timber Creek, and that is the question that in dealing with the issue of cultural loss, which was squarely put by Justice Mansfield in the first Timber Creek case, which led up to the Timber Creek decision of the High Court, he addressed the issue of, well, compensation involves just not essentially the market value of the land or the economic value of the land, and we will deal with that no doubt in a later podcast. But I wanted to draw attention to the question of compensation for cultural loss. There was an interview that I gave back in 23rd of February 2000, 23 years ago, and I gave evidence in front of the Joint Committee on Native Title and the Aboriginal and Torres Strait Islander Land Fund. There was a review of the then Native Title Amendment Act 1998, and they were looking at it in relation to Australia's international obligations under the Convention on the Elimination of All Forms of Racial Discrimination, which in some ways is a parallel of what you were speaking about in your presentation. I gave evidence at that particular inquiry. Remember, that was 23 years ago. And I'm quoting from my own evidence from Hansard, and I said that, look, I think there's also an issue about Section 5131 of the Constitution, the just terms provisions. And I have to say that in 100 years, I am amazed in this country there has never been a court case trying to determine what the notion of just terms is. In some respects, that is helpful because it means that we have to look at just and fair compensation, and that really came out, as we know, of the Fifth Amendment of the American Constitution, and is one of the main sources of that particular part of our Constitution. So here we are today in March 2023 addressing the issue, well, was that approached by the High Court in Timber Creek? Well, I would argue that it was, but it was addressed in a very subtle way because clearly it was in the mind of the judges, and you won't find it anywhere in the judgment, but it was clearly in the mind of the judges, well, we have to look at native title as a form of right to land which doesn't come from the Crown, and therefore there may be a bit of it which could be regarded as the economic loss involved, the market value of the land. But on top of that, there's another bit of native title, which is what we call the cultural loss, and therefore the question of compensation. And you can imagine the judges mulling over that and talking amongst themselves and to their researchers about it and saying, well, look, we're facing squarely this very issue that I raised on the 23rd of February 2000. What is just terms? And they were facing that clearly with the question of compensation for cultural loss. Now, there's been some thought about that, whether or not it would be possible to construct a framework for dealing with compensation for cultural loss, or at a broader picture, solatium. And Justice Edelman, in his part of the Timber Creek decision in the High Court, was quite clear that he was dealing with compensation for cultural loss, and he intriguingly said, well, I received no submissions about the broader picture of solatium, and he essentially left that open for a future court case. That's often something that happens in High Court cases. But he did address the issue of cultural loss. Now, if you recall a little bit earlier in my discussion here, I pointed out that there'd been no real consideration of such things as solatium, or even that component of solatium, if it's even part of solatium, which is this cultural loss question, because it doesn't arise in our Anglo-Australian property rights merging out of the English common law. Spike, I think one of the important issues is that, as I said at the outset there, you have to look deeply sometimes into the judgments of the High Court. I gave the example of the crocodile and how it took an opportunity for the High Court to sort out some legal issues that had to be done. In the case of Timber Creek, I believe that what they've done also is to rather tantalisingly take us towards an understanding about exactly what just terms really means. And yet again, we've got this example where they're using the Timber Creek compensation case as a trigger to get them into that very discussion. Now, we said at the outset here that native title is different from other sorts of property rights in Australia because it has another component to it, which often used as the word spiritual and cultural attachment, and that perhaps could be combined within the more well-known compensation head of solatium. But in the case of Timber Creek, issues were never, submissions and issues were never raised by the parties in relation to solatium, and it was only the issue of cultural loss that needed to be addressed. And as I said,
So just to stop, for the benefit of the audience who are not familiar with the word solatium, that's for want of a better word, for special cultural value.
no, it's more than that. It has its roots in our compensation legislation in Australia, where it's essentially the word is interesting. We can pick up the word solace in it. So it's essentially a head of compensation aside from the market value issues and the other sorts of things like special value and all the other things which is commonly found in the legislation. On top of that, it's an additional payment which is as a result of the, as I said before, the forced acquisition of the property. In the case of our market value approach to non-Indigenous property rights, as I said, it's a very small amount of money. But of course, in native title, as I did allude to, it was possibly the largest. And of course, Timber Creek showed that to be the case. 1.3 million was the allocation, but not to solatium. Justice Edelman, in his decision, his component in the Timber Creek decision was at pains to say, well, I received no, as I said a few moments ago, I received no submissions in relation to solatium, and so therefore that is for another time. And so I've only received submissions in relation to cultural loss. But I believe that gives an indication of where the High Court was going, because the High Court was saying, well, all right, here is an initial opportunity to look at exactly what just terms might be, and conveniently, we've been asked this question, and here we are. We, as the High Court, are looking at the question of cultural loss. Now, if we don't understand what cultural loss would be within the framework of the traditional owners in Timber Creek, we won't be doing something which is just, and therefore not in compliance with Section 5131. That's the framework, I think, in which you could argue that was the overarching thoughts behind the High Court's decision. As I said, you can't find that anywhere articulated in the case, but it's certainly embedded in it, because otherwise, why would they have done that?
Why would they create that level of
That's right. Why did they give
recognition,
so much attention to cultural loss? They received submissions, there's no doubt about that. And in fact, they received very significant submissions. And I think it's worthwhile for a moment, if you could bear with me, just looking at some of the things. For example, in the major judgment, in paragraph 168, the court goes on to talk about such things as that the native title holders observe essentially the same rituals and ceremonies as were practiced by the ancestors more than a century ago, and these ritual and ceremonial practices are largely and inextricably bound up with the land and the waters around Timber Creek. And then they go on to say, the judges, that examples of ritual and ceremonial practices include high-order ritual practice, initiating rites, head-wearing ceremonies, protection of dreaming sites, traditional methods of hunting, fishing and gathering food, and ongoing practice of ritual and exchange. And further, they go on to say that, as they're quoting from the full federal court, that native title holders are the gatekeepers of preventing harm to others and avoiding injury to country. And so they end up indicating there that essentially evidence given to the trial judge, that's Justice Mansfield in the first federal court case, pointed to a link between the symbols of the higher order ritual and proprietary interests in land. So you can see the link across. You can see that what they're saying is, well, look, this cultural impetus, these losses which are being claimed in terms of impairment or extinguishment of the culture, these are part and parcel of proprietary interests in land. Remember I said before that in the case of non-Indigenous property rights, we don't allow those. That, I think, is a direct hint about exactly where the High Court was going. They were looking at, well, we have to be satisfied that we, as the High Court, are addressing correctly the question of compensation for native title being impaired or extinguished, and we're asked specifically to look at cultural loss. And then they say very clearly that they see it as being, there is definitely a link between the higher order ritual and proprietary interest in land. Now, we don't see that with non-Indigenous property rights. And I think that's, in my mind, a very clear indication of where the court's going. They're seeing native title as having a component in it which, to be compensated fairly and justly, to be justly compensated, it has to be addressed. And so they say further, the rituals and ceremonies are signal a right to country which stems from the dreamings. And so I think that told us where they were going in terms of the question of just terms. That the court was saying, well, we're presented for the first time ever with having to address just how you would assess compensation for this peculiar property right known as native title. Peculiar in the sense it doesn't come from the Crown. Not peculiar in the sense it has any peculiarity. It's something that's very familiar to the traditional owners, but it's certainly peculiar in the sense of the existing common law in Australia, and certainly in the sense of the existing legislative framework for compensation.
Was there a reason why solatium wasn't specifically put in that case? Was there a reason why the claimants didn't make a case for solatium in addition to the additional amount? I mean, cause it seems, because as you say, it wasn't classed as solatium. So this wasn't an evolution, or it wasn't a clarification of solatium. It was a clarification of something other than solatium.
Yeah, that's an interesting question, and I've mulled over that. Justice Mansfield in the first case, which led up to this one, was actually adopting solatium as being the tool for compensation. The High Court went out of its way to say, well, look, we've actually not received anything which fits within the accepted framework of what would be solatium, but we've received lots of submissions in relation to cultural loss. And so therefore, as the courts do, it can only address what it's been asked to do. Now, as I said there, Justice Edelman left open the door for essentially another case to arise at some other time in the future where the bigger picture of solatium could have to be addressed.
I mean, was something that I flag this because you might recall there was a paper I wrote with Ulai Bayer where we talked about SIV, Special Indigenous Value, from a Pacific context,
Sure.
Where the legal frameworks are slightly different. Did Timber Creek not specifically adopt solatium, but do you think it then erred on what could be classified as special Indigenous value?
I think what the High Court did was to follow a line of reasoning which has often been, I suppose, ignored in a lot of commentary, that, oh, well, there won't be any more new heads of compensation, that the existing framework of settled Australian property compensation law will provide the basis of even dealing with native title compensation. Now, the reason why I say that is that there was some fairly trenchant criticism by people in the anthropology area who believed that the existing legal framework for compensation in Australia was inadequate to deal with the issue of, compensation for the impossibility of compensating someone for their cultural loss. Well, the High Court clearly showed that can be done within the existing framework. But one of the interesting things about it is they moved beyond solatium, and in some respects, I mean, you've asked me there, why didn't they? I think there may well have been a sigh of relief to the fact that there wasn't submissions about solatium, because if you accept that argument, solatium is a huge issue, because in New South Wales legislation they've removed the word solatium and replaced it to actually be losses associated with your with essentially the dispossession of your place of living. Now, in terms of the framework of native title, that's a huge universe for compensation, and so to a certain extent, by narrowing it down to cultural loss, was first of all a recognition that, hey, this is the start of a sensible recognition that native title does have to fit within the just terms framework in the Constitution, but to do that there's complexities in that which have never really been addressed before. And it raises the issue that maybe we now have We have within the framework of existing compensational law and practice solatium, but I would argue that as a result of Timber Creek, we now have an additional head of compensation known as cultural loss. And also solatium is the bigger picture. Now, as you quite rightly say, maybe cultural loss compensation could be seen as being part and parcel of the overall compensation picture for solatium, or maybe because it reflects culture and addresses culture, maybe it's appropriate that it be dealt with separately as it was.
As a special Indigenous value component.
And of course, as you said before, why didn't they address solatium? Well, I suspect there could have been a sigh of relief, because solatium is so broad and so all-encompassing, and it no doubt will arise. And in fact, on that point, I think it's worthwhile noting that the joint judgments, at the end there was a recognition of some advice which had been received from some of the experts in relation to the rights that are held in terms of culture by the traditional owners. And to quote, there was a mention there in the court case, it's at paragraph 170, dreamings are spiritual beings that performed actions that resulted in physical and spiritual modifications to the countryside. As some dreamings range widely over the landscape, their spirituality is believed to encompass more than one country. That's interesting. The relationship between an individual and the dreamings is a personal one. Dreaming is regarded as an absolute force, and its requirements and mandates have about them the immutable quality of law. I need to unpack a little bit about that. That phrase at the end is interesting, the immutable quality of law. So it could be argued there that in a way, in that part, the judges were saying, look, immutable quality of law, what is immutable in Australia? Amendments to the Constitution, you'd nearly have to argue. And there's no way in the world Section 5131, the Just Terms provisions, will ever be changed. That's got to be an immutable quality, certainly of property compensation law and practice in Australia. Secondly, it talks about the individual, the fact, and this is really interesting, it says there that it believed to encompass more than one country. If I'm reading that correctly, what they're saying is that, well, look, even though this claim is about these particular traditional owners who are the custodians of this particular Indigenous right to land, but they also hint there in that maybe it also could be recognised as being associated with other adjoining language groups who also have native title rights and interests. Is there a clear cadastral boundary? And of course there's not.
Not in a dream.
There's no cadastral boundary between those people's culture and these people's culture. And that's indirectly, as I said, indirectly what they're picking up there is that those things are obviously not in the framework that we would see as a spatial definition, the classic territoriality of property rights, the exclusivity of what we're looking at. And you can see there's some unpacking going on here of accepted approaches to how we define property rights. And as I said, once you start to look at the Timber Creek decision and you read it more clearly, you can see that there's a definite hint about the way in which the High Court was moving towards a clarification of exactly what terms of compensation which are just would be when they're looking at native title. And I think there's two good examples of that. And the complexity involved in that in itself, particularly the issue of an interaction between the property rights, the interest in land held by the traditional owners in Timber Creek, and the interaction between those rights and interests and the adjoining or nearby or maybe a bit further away rights and interests held by other Aboriginal people. As I said before, we could be dealing with a whole universe of rights and interests, which to start to get into that, we'd still be receiving submissions even now in 2023. So there had to be, I think, a recognition that there's a limit to what they could do in the one case, and that's appropriate because remembering we started out with Mabo in 1992. Later onwards, we had Yanna versus Eaton, which actually confined the colonial states' ability to be able to control everything in land and resources to the fact that they were now put in a certain box. I'm not certain that there was a happiness in the Queensland government as a result of Yanna versus Eaton, but we know it was certainly reflected in the Queensland and the New South Wales and in the other states' legislation when they tore apart the right to land and the right to water in non-Indigenous property rights. So things flow from High Court decisions which are often not perceived at the time, but certainly, we've now got the water legislation in the States, and they came really directly out of the ability of the Crown to only regulate certain resources, not to own them.
I mean, obviously, in this is something we may return to in a future episode. We've got the recent case in the Murray Islands where, as with over 40,000 square kilometres of land and sea, where it did go into the countries of different groups, and that determination at the end of 2022 was the result, should I say, of perhaps 30 years on from Mabo, where again it was the same families, and again Murray Island was pretty central to the whole issue, but they were able to reach an agreement without real dispute because it was recognised that the sea is a highway for not just one group, and the dreaming is a highway, sure, not just for one group. So it isn't. I mean, we tend to get in customary land issues, there's always this whole dimension of, it should be recorded and registered, and the geospatial people and the cadastral surveyors get involved, and it's all about sort of a very first world regimen.
Of course.
But here we're into the metaverse. We're into something which is not only supposedly inalienable, but obviously Timber Creek saw a level of alienation,
of course,
for the reasons that you gave earlier. But it's not just the fact that we have an inalienability, supposedly, but we actually are going into layers of understanding which is beyond that sort of very Western finite. And obviously here, as we've worked from, and much of your work over the last 25, 30 years has been involved in working within the constraints of the pre-existing supplanted Anglo legal system. And as I've referred to before, and you say we can't change in the Constitution section 5131, but we certainly have a situation where when the Constitution was crafted 125, 130 years ago, they were not thinking about these sorts of issues, because that was crafted from an Anglo-feudal understanding of property law, with the Crown as head, without these important dimensions. So I think yes, it's very, very relevant that you reflect there on not just the immutable nature of law, but what law.
That's right.
The law of the Indigenous people, or the law of Section 5131 of the Constitution, which is very much in an Anglo-colonial supplantation of legal understandings.
And look, you're right, but at the same time, I'm not naive to the sense that I certainly don't see the Australian Constitution as being flawless. But one of the things which I think we have to recognise is that the quality of our judiciary, once they reach the heights of membership of the High Court, they are very skilled property lawyers in a lot of cases. And so consequently, you could see that in the reasoning in Timber Creek, where they're looking really at the issue of, well, we have to make certain that we, as essentially the custodian, which is the role of the High Court, to protect the Constitution, and in there, Section 5131, as you quite rightly say, was written over a century ago. But the reality is that Section 5131, the word just terms, was taken pretty much out of the Fifth Amendment of the American Constitution. Not that we can gain much comfort from that, because there was the whole Lockean approach in America about protecting private property rights, and they were frightened about the new federal government, and there was great deal of suspicion about what should happen through the protection of private property. To a degree, I think that influenced what was there in the Australian Constitution. However, in the question of this mysterious word called this phrase, just terms, the High Court started on the pathway in Australia of producing a homegrown Australian common law approach through the case law of exactly what just terms means. Now, with your kind forbearance, I want to extend that a little bit further, because as is often the case, I gave the example of Yanna versus Eaton, where we've had now an understanding about what the limits are of what the Crown owns physically is in the sense of private proprietorial rights. And so consequently, we now accept that. It grew out of a decision of the High Court. And we know, of course, that even in the Mabo case, Justice Sir Anthony Mason at the time was, I remember, interviewed on the ABC by Andrew Olley, who's long been dead. And he asked His Honour, who was the judge, the chief judge in the High Court at the decision in Mabo, they asked him, well, the court's being slandered to a degree or questioned about whether or not, they were activist. Well, the court was very conservative in Mabo. He listed the reasons why they had nowhere else to go. 1975 Racial Discrimination Act, which flowed from Australia's international obligations to stop racial discrimination. We had the International Court of Justice in the same year in the Western Sahara case saying, well, look, this long-term legal fiction about terra nullius, and I know there's arguments about where it came from, but it certainly was a useful tool to question that. And of course, we'd also had the previous decisions of the American Supreme Court in the 1830s. Johnson and McIntosh, Chief Justice Marshall, had moved along the pathway of a recognition space for existing Indigenous rights and interests, notwithstanding there had been the imposition of British sovereignty. So he explained very clearly that really the court didn't have anywhere else to go but to actually address the question of the survival. And we know in earlier cases there'd been a hint towards that, but that's what the court did there. And in the case of Yanna, as I said before, the court did something that had to be done. It had to recognise, tidy up, as I said before, a bit of outstanding paperwork in terms of property rights. And in the case of this, you can see my argument flowing through is we're now on the pathway to start to understand what just terms is. And thankfully, yet again, it's coming through the innovative pathway of the High Court addressing at least a little bit of what just terms is. And you can see, of course, that there is a bigger issue there that well, if that's exactly what just terms means in terms of native title, as I said before, with your forbearance, let's look a little bit further beyond that. It's quite clear that the existing property compensation law and practice in the states and the Commonwealth is no longer fit for purpose. There's no doubt that taking people's property for whatever necessary public works are necessary for the state or the Commonwealth, is it just adequate that people would receive compensation just purely on the market value with a little bit more for their disturbance? And it's becoming obvious in a lot of cases that, as I said before, it's not fit for purpose. Now, a prime example would be in the North Road out of Adelaide. That road has been the subject of a call for widening. It's going through at the moment. But there's questions being raised about the compensation that the people are receiving under the legislation, appropriate legislation, receiving market value. But putting it simply, they've got a house on a very busy road, it's worth $1. They receive their $1, perhaps a little bit of solatium, maybe a few thousand extra. But what are they going to do with the $1? They want to stay in that area. They've got cultural connections. You can see where I'm coming from. They want to move into the quiet street next door. $1 won't buy them the house in the quiet street. They'll need $2. But that's not the way we operate. So you'd have to say, putting our just terms hat on, that's really unjust.
Yep.
And so even though it starts in native title, you can see where I'm coming from, we're starting to have a reconsideration occurring of just that. And you can see where some of the roots of that lay. In the third runway at Mascot Airport some years ago, the Commonwealth Government decided to start compensating people for the impact beyond the boundaries of the airport as a result of airport noise and double glazing. Some of the properties were even acquired. Why did they do that? Well, part of the reason was the fact, one, it was being done by the Commonwealth, who are probably more sensitive to these issues and of just terms. And then flowing from that, you can see that what's happened is in more recent years, you've got in New South Wales the construction of the motorways up and down the coast, and a huge amount of noise attenuation borders are being put up, often nothing to do with the compulsory acquisition, purely because there's seen to be an unacceptable environmental impact coming from the noise generated by those motorways. And so if you can follow that argument, you could have to say, well, it's clearly moving much beyond just simply the cadastral boundary, what's being acquired. We're now putting money into people next door who are not affected by it, but will be affected environmentally.
Well, it's the injurious affection dimension,
Sure,
which
sure.
has always been in the UK.
Of course.
The UK model.
So there is, I think, now an understanding, and I think it's definitely coming out of the Timber Creek discussion, that there is a broadening of the potential for compensation. And we've recently had, of course, the question of the Ellerton Drive extension around Queanbeyan. So when the compensation issue was addressed, clearly Queanbeyan Council and Queanbeyan itself as a city is just over the border from the Australian Capital Territory, where, of course, the capital of Australia is located, Canberra. But more importantly, the compensation that would have been paid by the council for the acquisition of that land for the Ellerton Drive bypass. You've got to imagine it's a big motorway, avoiding the traffic, making things a bit better for the people passing around and through Queanbeyan. But the reality was that because it was being undertaken by the council, the proposed acquisition had to be submitted to the Department of Planning in the New South Wales Government, and that was automatically referred to the other relevant and interested government agencies. One of them was the Office of Environment and Heritage, and they required that there should be attention given to the replacement of the vegetation on that land. Ordinarily, of course, that would be ignored, but in this particular case, the Office of Environment and Heritage required the council, in terms of compensation, to acquire a significant tract of land further east of the town of Queanbeyan, where a similar endangered ecological community was located, of eucalypt forest, and the council had to acquire that and enter into a maintenance agreement for the adjoining property owner. And so that was an addition to the market value of the land. You could well ask, well, at the end of the day, we can see a widening of compensation provisions, not only just in terms of trying to understand what just terms might be within the framework created usefully for us out of the native title decision, but also you can see that there is changes occurring in terms of what is regarded as adequate compensation. It isn't just market value any longer. I wanted to turn in closing, Spike, to the lessons that we've received out of the Timber Creek case. And there's no doubt that there was an issue which the High Court said at 225, paragraph 225, that the compensable acts affected, quote, not only the precise geographical area of the lot on which the act took place, and goes on to say, and that the land and everything on it are, quote, organic parts of one indissoluble whole. That was the Timber Creek decision at paragraph 223. Now, it was important that the court took into account the very nature of how native title doesn't fit within the way in which we, in terms of the English common law imported into Australia, define property rights. That critical issue of exclusivity and territoriality was addressed clearly in terms of the way in which the property rights in Timber Creek were being changed, extinguished, whatever, and also it wasn't just the boundaries of the land. Now, one of the issues, of course, is that the High Court probably unavoidably was required to import elements of intuition into their decision. In other forms of compensation, such as compulsory acquisition of private property rights held by non-Indigenous people, there's some fairly well-worn paths and quite calculable, although somewhat problematic, assessments of compensation. And so the issue in terms of questions of solatium and that within the existing, albeit very limited framework, are also initially regarded as intuitive, but they're very real. In the case of native title, the High Court recognised that there was a dimension there which was not only just, as we do it as a future podcast, the issue of exchange value, but there was also the question of cultural value. Now, in closing, I think it's worthwhile commenting that there's no doubt that Justice Edelman was very clear in saying that, look, we're not looking at solatium. We are looking at only compensation for cultural loss. But where that leads us in terms of compensation more broadly, and I suppose, again, we're looking right back to how the case law develops in Australia, how it tends to come from decisions of the High Court ultimately, which are often reflected in subsequent changes to legislation. That may well be the pathway we're on already at the moment. And I think there are lessons globally because while, as you quite rightly said at the outset, the Constitution in Australia was written a long time ago, but it's interesting to see the way in which the High Court has looking at one particular, albeit very narrow, aspect of the Constitution, Section 5131, the notion of just terms, and using that as a tool to look at the question of compensation, just terms compensation for native title. I'm quite certain that the people who wrote the Constitution back in the end of the 1880s and 1890s would have had no idea that this application of Section 5131 to the very issues we've been discussing this morning should end up raising all sorts of issues in terms of just how broad compensation should be. That while there was always a commentary, particularly from the other disciplines, that, there'll have to be a brand new branch of compensation law for native title, it didn't happen. And what the court did, as often happens in Australia in the way in which, and also in the way in which the Canadian Supreme Court operates, we operate within the framework, but we reinterpret the legislation or the framework for the circumstances that exist.
So it is dynamic. It is evolving.
It is evolving.
And we've got some wonderful lessons from you today in your reflections on the Timber Creek case, and particularly how being able to see that even though we are in some ways here in Australia sort of locked in or handcuffed within one structure, what you've really done, I think, is opening listeners, well, I'm going to say eyes, open listeners' ears as to how the High Court is being reasonably nimble in and adaptive in its way that, despite the constraints of the pre-existing structures of the legal system, it is actually demonstrating that it is able to provide a greater level of clarity when it comes to dealing with customary land, which is, after all, what this podcast is all about. So thank you very much, John. I'm sure that the listeners have found it very insightful and intense, and people will hear your passion when it comes to talking about all things native title. And I've just been sat here today enjoying you espousing on all these issues. So I hope that the listeners have also, and I'm sure they have, gained a great deal from it. So thank you for joining us on the Customary Land podcast today, and we look forward, because you've already flagged that you will be returning, and that's excellent. So a forthcoming episode when we'll continue our conversation in front of microphones and cameras, because we have these conversations all the time. So thanks very much for your time. And in closing, I provide a normal disclaimer, which is, and I'll read it from here, which is: the views and insights and opinions shared in the Customary Land podcast are those of the host, any guests, in this case my distinguished guest John Sheehan, and others that they may cite. They don't constitute legal or financial advice and should not be construed as such by any individual, group or organisation. Before undertaking any dealing or action relating to customary land, individuals, groups or organisations should obtain professional advice from a qualified lawyer, an experienced valuer, and or a chartered certified accountant with specialist expertise in your particular country. Alternatively, you can contact Customary Land Solutions for advocacy, advisory and capacity building solutions for customary and Indigenous land earning groups and trusts on land management, leasehold, valuation and resource compensation issues. Our email address is contact@customarylandsolutions.com. Alternatively, if anything has come up in this podcast today which you'd like to discuss, flag or comment on, you can always reach me at contact@thecustomarylandpodcast.com. So from John and me today, thank you for listening. We hope you've enjoyed it. And until the next podcast, stay safe, stay well, and look forward to you joining us next time.